instruction. This is our State Board of Education meeting, November 5th, 2014. If I could have roll call, please.
Present.
Mr. Elster?
Present.
Dr. Freitas?
Present.
Mr. Hendry?
Yes.
Ms. Neal? O'Brien?
Present.
Dr. Oliver?
Present.
Mr. Walker?
Present.
Mr. Watts?
Present.
Vicker?
Present.
Superintendent Ritz?
Present. If you could all stand and say the Pledge of Allegiance with us, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I'm going to apologize right off the start. The light is like in my eyes, so I can see no one's faces, literally. So I'll have to rely upon some other board members if I miscue getting someone up here or anything like that. Approval for the agenda. I believe that we had a request to remove item M from Mr. Oliver.
Yes, Madam
Under
Superintendent.
discussion.
Yes, we can remove that. That would be
Okay.
great.
Any other changes to the agenda?
Madam Chair, I would like to request moving items E, F, and G to immediately after A.
All right. Any other changes to the agenda? Seeing none, is there a motion to approve the agenda?
So moved.
Is there a second? All those who approve the agenda signify by saying aye.
Aye.
Those opposed, the agenda is approved. The approval of the minutes, you have two sets of minutes, October 1 and October 15. We'll take them separately. Do I have a motion to approve the October first minutes?
So moved.
Second? Second. All those in favor of approving the October minutes signify by saying aye.
Aye.
Those opposed, the October 1 minutes are approved. We have a motion to approve the October 15th minutes.
So moved.
Second? Second. All those in favor of approving the minutes for October 15th signify by saying aye.
Aye.
Those opposed, the October 15th minutes are approved. The next item is the statement of the chair. I want to let everybody know that we are having the Teacher of the Year dinner on Friday evening, and I want to thank Brad and Carrie personally for attending. It should be a great event, so I'm looking forward to that. I also want to let everybody know that we've had Outreach has provided 6 trainings with the Focus and Priority School leadership teams. They've all been attended, and we are very excited about that, and they were great trainings for the Focus and Priority School leaderships. And then we also have 6-part leadership series for administrators on leading turnaround work. In addition, we've had 5,577 educators join our online communities of practices for the standards since launching it in August. So that's very exciting that we have the teachers talking with teachers amongst themselves with the standards in the state of Indiana. Are there board members' comments and reports? Yes, David?
About 2 weeks ago, we had the opportunity to attend the National State Board of Education conference in Denver, and there were 4 of us who attended. In addition to myself, Tony Walker, Gordon Hendry, and Brad Oliver attended. It was an opportunity to sit with State Board of Education representatives from throughout the country as well as other state superintendents. And it was a really valuable experience in that we got to talk and interact with other state leaders. And it's interesting that the issues that we're facing in Indiana, they're facing in other states also. And it was great to have that dialogue about how they're handling certain kinds of things. I want to also mention that Gordon Hendry is part of the board of directors now for the National State Boards of Education, so congratulate him on that. And Tony Walker was elected to some subcommittees and other leadership positions. So we are well represented at the national level. So I'd invite my colleagues to make any kind of comments they'd like about the National State Board Conference.
Yeah, Gordon?
Well, I would just say it's an honor to sit on the board of directors of NASB, and I will hopefully represent Indiana well. I think it's a very important organization that brings together thought leaders, best practices in education policy, and is a tremendous resource for us as members of the Board of Education, as well as others from across the country. And I think just some takeaways from the various sessions we heard from really just thought leaders from across the country, Stanford University professors, the former CTO of the United States government, really inspirational discussions. And I think from my own vantage point, I think takeaways as it relates to how do we improve our use of technology in our schools is one issue of particular interest to me. So anyways, I would just echo David's comments that it was a excellent annual meeting, and I think all of us had some very positive experiences. Thank you.
Brad, did you want to make comment?
Just to point out that 3 of the 4 members that were there are on the strategic planning committee, and I think it'll be extremely valuable to the 3 of us that are trying to help lead the board in that area too, because as Gordon and David shared, just a lot of the ideas, the access to information. I attended a session with NASB on the publication side where they're trying to develop a more digital central repository for topical information for state board members that will be extremely helpful as we go forward. So very good meeting.
Tony, did you have any comments? Dr. Walker?
He's
on there.
Can I just add, we mentioned the Stanford professor, and if you're in education, Linda Darling-Hammond is a name that we know, and she was there and available immediately after the presentation, and that was really valuable. And the Educator of the Year award went to the State Superintendent of Kentucky, and he presented a speech and was just passionate about what we do as educational leaders, and that was really inspiring for me. So thank you for letting us provide that update.
No problem. We have general public comments next. So sorry.
Sorry, if I could. I did have a comment I'd like to make.
Oh, sure.
Wanted to share with our colleagues, as we approach our work today on finalizing the ADAF letter grades, I did want to make just a few comments. The State Board of Education, I believe we were wise at our last meeting on October 15th to table any action on the final grades and allow Legislative Services Agency a chance to complete their independent calculation of school letter grades. Unlike last year where preliminary letter grades were delayed, not final letter grades, preliminary letter grades were delayed by the department in their embargo release to schools, this year our schools have benefited from having sufficient opportunity to raise concerns and file appeals. And the testimony of school leaders last month and through subsequent correspondence has shed light on growing concerns over how the department's interpreting the application of accountability rules, particularly when it comes to schools with atypical grade configurations or instances where grades are calculated with missing or incomplete data. And I think that when the State Board of Education becomes aware of those concerns in a school's preliminary letter grade, I believe the board does have an obligation to ensure fairness by weighing all available data and making decisions with respect to which computational models inside the current ADAF accountability rules produce a grade that's most reflective of the school's actual performance. I said this to somebody recently, the A-to-F letter grade system is not perfect, but it is useful. Since its implementation and intentional focus on improving achievement has resulted in the total number of schools receiving an A letter grade growing from 670 in 2012 to 806 in 2013. More encouraging is the number of schools receiving a letter grade of F has decreased from 131 in 2012 to 100 in 2013. Just as a student letter grade provides timely feedback to parents, school letter grades serve a similar purpose, allowing school leaders, teachers, parents, and community leaders to engage in critical conversations about how to improve the effectiveness of their schools. It would be my hope as we complete our work today that the State Board of Education would apply the following logic. First, to the extent that the current ADAF rule is clear in its application, application, we should issue an appropriate letter grade as calculated by the rule. But to the extent that the current A to F rule is unclear and insufficient in evaluating a school, we should unapologetically use all available data and our collective wisdom as a board to assign a letter grade that's most reflective of a school's actual performance. Our students and our teachers have worked hard, and they have every right to expect a letter grade to be issued that reasonably represents their actual performance. Finally, I just want to make a brief comment about embargoed data. I was deeply disappointed to learn at the conclusion of last month's meeting that the Indiana State Teachers Association had access to embargoed data, the same data the board staff was denied. When I inquired about this, I learned that the department is requiring board staff to submit a written request for such data, similar to the request required by the members of the media. I have serious concerns over the manner by which the department determines who can have access to embargoed data, and perhaps the board should take steps in the future to pass guidance on who can have access to sensitive data so that an inadvertent social media tweet doesn't undermine the embargoed nature of preliminary grades. I would hope that in the future, working with Superintendent Ritz, that the board would take steps to ensure that department staff provides board staff with all critical information as needed for the board to carry out its statutory responsibilities. I've said this many times before, but I just believe we serve our students and our teachers best when timely and accurate information is provided to the board and when we complete our work collaboratively, putting the needs of our students first. Thank you.
Thank you, Brad. We have general comments now. Looks like we have Pastor Anthony Wallace. And for general comments, I believe it's 3 minutes.
Superintendent Ritz, ladies and gentlemen of the board, good morning. Good morning.
Good morning.
Thank you. Thank you. I have a concern, and naturally being a member of the community, we're always concerned about the goings-on. And I've read of the plan of the IPS board and with the A, B, and C considerations, and I want to speak something positively in the beginning here and just take for granted that it's going to happen. I look forward to the opportunity for a committee meeting with the stakeholders, the community of the Arlington and Devington area. I pastor a New Spiritual Life Christian Church, which is located in the Devington Plaza at 6062 East 46th Street. I'm going to share some of my concerns with you and let you know that there will be a letter forthcoming addressing the A, B, and C options that we have been given. In my discernment, I see that the A and C both allude to the closure or a temporary closure of Arlington High School. In consideration of closure of Arlington High School, let me say this. In the establishment of the community, the first building blocks put into place by the families are the church and the schoolhouse. By the same token, the same signs of a community on the verge of collapse are the removal of the schoolhouse, the church, and the structured family. To add to the devastation of this community is Devington Plaza. This is a retail entity on the brink of infrastructure failure. The New York-based ownership, as far as I'm concerned, at best is described as slumlords. The removal of the local schoolhouse, which is the only anchor or entity resembling a productive community, would hasten the failure of Devington Plaza and thereby doom a community currently teetering on the brink of collapse. Ladies and gentlemen, the historic collapse or consequence from such a collapse is the flight of the more structured citizenry, leaving behind a remnant of socially ill and lethargic majority to usher in a once thriving community into a corridor of blight. Community is not the inevitable result when people live in close proximity to one another. The associations that form a community resemble that of an ecosystem where the complex interactions depend upon a few resources or sources for sustenance which are as vital as air, water, and sunlight. If we degrade either one of these resources, and the ecosystem is then vulnerable to a systemic breakdown. So too are our communities. The integral parts of and active participants in a community, beloveds, is sunlight, or like sunlight upon an ecosystem, is the family, the church, and the schoolhouse. And finally, we must give further consideration to this continued practice of expulsions within these school systems. The deprivations of these children's rights carry with them long-term consequences that affect the child's potential for full and harmonious development of his or her personality, and not to mention their rights to social development, education, and academic standards, or an adequate standard of living. Thank you. Neither the community nor our children need a Kevorkian assist.
Thank you.
Thank you.
Thank you.
The next speaker is Sue Dillon.
Thank you for allowing the public to address you. I am the president of the Central Time Coalition, and I think we've met before. I am here today to inform you about a bill, 127, Senate Bill 127, that was adopted by the legislature in 2005. It's now almost 10 years, and that it was intended to resolve the time zone controversy in Indiana, or the time controversy. It had two steps. Step one requires Indiana to observe daylight saving time throughout the state, and that has been enacted. Step two urges Governor Daniels to petition the United States Department of Transportation to initiate proceedings to hold hearings on the issue of the time zone, or time zones, in which Indiana's 92 counties should be located. The governor did request hearings, and USDOT said, "That's not our job. You didn't tell us where you think the boundaries should be." And therefore, that second step has never occurred. This year, there will be a resolution introduced by Representative Thompson requesting a study committee be held here within our legislature during the summer to discuss what are the factors that should determine where should the boundaries be here in Indiana. We have our own opinion, and our second purpose for being here is to hand our education report to you so that you will understand why we consider this an education issue. It is entitled "The Detrimental Impact of the Eastern Time Zone Designation on Indiana, Its Students, Their Education, Its Communities." You may have heard, I'm sure, on August 22nd, the American Academy of Pediatrics came out with a very strong policy statement about the start time of schools for adolescents not occurring before 8:30. You may not have had the opportunity to read that. It's in here in its entirety. Also in here in its entirety is the report mandated by the legislature about chronic absenteeism that came out last year. Also in here is research that the coalition has done when every day they check to see what schools are calling school delays. Last year, it was horrendous, as you know. I know you're well aware. Thank you. So, one other thing, are you aware that Indiana ranks the second highest in the nation with suicide attempts among its adolescents? There are reasons, and they are explained in here. We think it's important.
Thank you for your report. Thank you.
My assistant, Jim Disney, will pass these out to you. Thank you.
Next item on the agenda is consent agenda. I don't have any others for general comment. We will call the other public comments during the actual item. Next item on the agenda is the consent agenda. Do I have a motion to approve the consent agenda?
So moved.
Second?
Second.
All those in favor signify by saying aye.
Can I ask about the date? Can I bring that up?
Sure.
There's mention
The
on-
dates of,
There's mention on the memo regarding the meeting dates.
oh, correct, there is.
We currently would be scheduled for March the 4th and May the 6th, but with I-STEP testing running over those, there's consideration of moving those. And so
We may, thank you.
discuss if we're.
Thank you.
we're
Actually
voting on
had-
the March 4th or the March 12th.
I actually had that listed on my piece.
Great.
So we have, as part of the consent agenda for our board meeting dates, having March 12 or 13, which one is actually, is one of those on a Wednesday? Thursday, Friday? So, and then May 7 or 8, is that a Thursday, Friday also? Your preference for a Thursday?
I just would like to know, so for
Sure.
scheduling, but also I do appreciate the board and everyone's willingness to move those for I-STEP testing, because it is important to be there with my students for that.
So we'll replace March 4 with consensus here, I think, amongst us, for March 12, and May 6 with May 7.
One question, should we move the October date back a couple weeks as well, given the issues relating to 8F appeals?
I don't know. I think that varies in terms of how we're getting all the data calculated and everything ready. So I don't know that we need to at this time.
Well, it's just hasn't been the last 2 Octobers where we've had to have mid-month meetings, so I just thought we'd go ahead and nip it in the bud and move the October meeting back a week or 2.
Do you have the actual date for that, the 14th?
14th?
Would be the next Wednesday? Any, objections to us having consensus to that? Right, so we've got March 12, May 7, and October 14 in 2015. All right. Now, we have a motion and a second. Thank you, Carrie. All those in favor signify by saying aye.
Aye.
Those opposed? Consent agenda is approved. We're on to new business. The first to come before us is the resolution of petition MSB, CAB, and MEB versus Benton County Community School Corporation. I move that we take this under advisement.
Second.
Any discussion? All those in favor signify by saying.
Just 1 second. Is there a reason why we're moving to push it off of? I'd just like to understand the chair's.
We just recently received the actual documentation from the hearing examiner, and we need time to review it. We did not receive the original appeal, the hearing officer's appeal ruling.
Could we just go ahead and move that to the end of the meeting, and then during one of our breaks have the opportunity to review that so we can have the vote today?
Board counsel recommended to us in executive session that we may want to review the evidence that attaches to that.
Yeah.
Roll call, please.
Yes.
Yes. No.
No.
Brian,
Yes.
Oliver,
Yes.
Mr. Walker. Watts,
Yes.
Baker,
Yes.
Yes. Motion carries. Next item of business will be atypical schools. We have some speakers. First speaker is Robert Summers.
Thank you, Superintendent Ritz, board members.
You have 5 minutes. Thank you.
That's what I understood. First of all, thank you for the opportunity, and I want to tell you that I have a great deal of respect for the important work that you do. I had the occasion to staff your counterpart state board in Ohio, and I understand the difficulties that you face every day. I've had the privilege of working in education for nearly 40 years. I've been a classroom teacher, worked for the State Department, been an elected local school board member, superintendent of a school district for almost a decade, and I've had a special privilege of being education policy advisor for Governor Kasich in Ohio and Governor Fallon in Oklahoma, both of which I'm pleased to announce that got reelected yesterday. I've had the opportunity to work on performance systems and understand the complexities, and I can tell you that I think your legislature has crafted a very thoughtful process in a very complex environment. Carpe Diem Indiana, which I represent today, is seeking the proper application of a thoughtful law. First of all, the legislature recognized the challenges of a new school startup and gave the option of a growth-only provision, because when you're starting a new school, you have to have time to work with students that may or may not have received good education in the past. We were in our second year of operation upon when this report card was produced, and we feel that we should have the growth-only model applied to us. Second, the legislature recognized the challenges of very small schools and very small numbers. 2 reasons: security of individual students, but also the difficulty applying statistics to small numbers. We fell below the required number of students in the provision of the growth-only model, and therefore we feel that the proper application of the law requires a no-grade result for us. I'm especially interested in the fact that the proper application to fairly represent the school. Our actual achievement would have been a grade level higher had it not been for very small numbers. The participation rate, we had a 93.5% participation rate with our very small school, so if 2 students had come and taken the test, even if they had not passed them, we would have had a higher letter grade than what's being currently calculated. And I think that's an example of showing how the legislature properly provided a law that dealt with the small numbers and the beginning school. Again, we think the law properly applied requires a no-grade result for us. We support accountability. I've been on the advocating end of that in at least 2 states, if not more, from not only the classroom but in the legislature. But we agree with the Indiana legislature regarding the treatment of small, new schools. I think it is in the best interest of applying this law appropriately. I thank you for your time, and I'd be pleased to answer any questions you might have.
Thank you.
Thank you.
I think it's Sean Igum.
Good morning, Madam Superintendent and ladies and gentlemen of the board. My name is Sean Egan. I'm the principal and school leader of the Hammond Academy of Science and Technology, HAST, a charter school located in the city of Hammond. It opened its doors in September 2010 as an atypical model, middle and high school configuration. We graduated our first class of seniors, with 93% of them, this last May. Although we have consistently outscored the Hammond Public Schools, our A to F grades have been Fs and Ds. We would like the board to consider our appeals and listen to our situation. I come before you today to address the issue of our atypical school and the application of accountability metrics to HAST. Further, I would like to request the board hear our belated appeal at its next meeting or at any meeting and upon any timetable set by the board. HAST opened its doors in 2010 with grades 6 through 9. Each successive year, the school added an additional grade, reaching a full 6 through 12 cohort of students in the 2013-14 school year. Each year, HAST completed the required paperwork to inform the Department of Education of our changing configuration as we expanded into a full middle school and high school over the 4-year period. Today, we come before the Board of Education to address the changing parameters that were applied to our school, starting with the present and then working our way through the chronology of letter grades, appeals to HAST, by HAST to the DOE, and communication from the DOE to HAST in response to these appeals. At present, using the 2013-14 letter grade metrics, HAST's middle school received a B, the high school received a D.
The entire school's overall grade is a D because of the proportional weight carried by the high school grade, since more students are in the high school, 307 versus 260 in the middle school. The only data used to calculate the high school grade was the 2013-14 10th grade ECA pass rates in algebra and English. The 2013-14 letter grade includes no graduation information and no college and career readiness for our graduating seniors. This, according to the DOE, is because there is no comparative data to determine the HAS growth or improvement in these metrics over time. This is unfortunate, as this data shows that the success that HAS has enjoyed under the parameters set by the state core curriculum, as well as societal measures of success. HAS had a 92% graduation rate, a 92% college acceptance rate. 90% of our graduates had completed 3 dual credit hours or more, with one student completing over 50 dual credit hours. 20% of our students received academic honors and or technical honors diplomas. HAS graduates were awarded nearly $1.5 million in university scholarships, or over $25,000 per student. Statistics such as these are rare, but even more so for an urban charter school. This information was not used because there was no prior year data to compare it to. If that logic is extrapolated in reverse, our 2010-2011 years should not have received a grade, as there was no prior data that year for our middle school students either. We did not appeal our 2010-11 F that we received, due mostly to our belief that as a new school, we were just getting our feet wet and knew that we would improve. We did, however, appeal our 2011-12 letter grade. For that year, among other errors, no 10th grade ECA data was included. We had a 10th grade cohort. Their pass rates were excellent, above 80% for English language arts and above 70% for algebra. These were not counted. The reason, per Will Krebs, former Director of Policy Research and Accountability, was because our small student numbers in the high school did not warrant that data to be used. There were nearly 70 students in that 10th grade cohort at that time. I believe that this is a sufficient number of students per DOE standards to include the students' data, and it should have been counted for our grade. In 2013, HAST again appealed its letter grade. For the 2012-13 school year, 10th grade ECA data was included, and HAST was graded using a combined school model with elementary, middle school, and high school grades 9-10. This was even though we actually had an 11th grade at the time as well. This is also with the fact that the cohort of students was nearly the same size as the prior years. We appealed due to the blatant inconsistency of the application of the combined school model from 2011-12 to 2012-2013. In an email from the DOE's Debbie Daly to John Barnes and Amy Horton, also at the DOE, dated August 21st, 2014, Ms. Daly states, the school was assessed under different models in 2012 and 2013. Appeals were submitted each year concerning which model was being applied. Both the 2012 and 2013 appeals were denied because the application of the model aligned with policy as defined for the applicable school year. This then brings us to the 2013-14 school year in HAST letter grade. At a public meeting for school principals held at Crown Point High School last spring, at which State Superintendent for Public Instruction Glenda Ritz was the guest speaker, I raised my hand during the question and answer portion of the meeting. I identified myself and my school and pointed out that I was the only charter school principal in the auditorium. I then proceeded to ask what data points would be used to calculate HAST 2013-14 letter grade. I also stated that, contrary to what my traditional public school principals in the room believed, HAST wanted all applicable data points to be utilized. Superintendent Ritz replied that indeed, if the school had data for any of the categories used by the DOE, that data would be incorporated into our letter grade. This was welcome information for HAST. The 12th grade information would be included. Contrary to what the superintendent stated, and because I wanted to confirm this information, I began to contact individuals at the DOE, starting with our regional liaison. The remaining information and emails are attached to this.
Madam Chair, since he's just wrapping up, I would just request that he be given the opportunity to finish his statement.
You may proceed.
Thank you. I began to contact individuals at the DOE, starting with our regional liaison, Linda Randolph, who moved the question to Annette Johnson, who moved the question to Debbie Daly. On June 6th of 2014, Ms. Daly responded and restated very thoroughly how our school was measured in 2013 and 14, and how it would be measured from 2015 on, at which point the high school graduation and college and career-ready data from 2014 would be included. This may be good news for HAST moving forward, but it does not help address the inconsistency and unfairness in the grading of HAST to this point, given its atypical configuration. I would therefore respectfully request that the board review our appeals and consider them belatedly, given the information that I have presented. I am more than happy to answer any questions you may have. Thank you for your consideration. And again, pertinent emails are attached to this document as well, what I just read to you.
Did Hammond Academy of Science submit an appeal?
For this year?
Yes.
We did not.
Okay, thank you. Kevin Smith.
Madam Chair,
Yes,
may I make a quick statement here?
you may.
I just wanted to say, regardless of what happens, both Tony Walker and myself, Tony Walker, who represents the Congressional District 1, had the opportunity to visit HAST last year, and regardless of what the letter grade reflects, I can speak to the outstanding education that is going on at your school. So congratulations on your efforts. I think both Tony and I were very impressed with the level of instruction and with the students and so on. So I just wanted to make that statement that I've seen firsthand what you're doing at your school, and I would say keep up the good work.
I too visited HEST, and I would concur.
Thank you.
Mr.
Good morning.
Smith?
Good morning, Superintendent Ritz and the board. My name is Kevin Smith, and I'm actually the board attorney for the Hammond Academy of Science and Technology, in which Dr. Egan is the school leader and principal. I speak today before you to echo what Dr. Egan just stated, but also to add a bit of a procedural background as to why we're here today. I have been in communication with DOE through several members of the superintendent's staff, both Mr. Hartzer, Mr. Reski, and Mr. Barnes, and they are aware of the issues that Dr. Egan brought up. Additionally, I was in contact with Ms. Willie, who you, I believe, heard the appeal last month from Crystal House Academy, and I've known Ms. Willie for some time, and we were in communication over the potential appeals. We understand that the window of appeal that was announced had been closed. I can only tell you that I did not have notice, nor did Dr. Egan, outside of, I believe, what was posted on the website. And I can tell you that from our experience, we would hope that the board would consider a belated appeal in this instance because of the atypical configuration and because of the importance of that issue that is facing this board and the state. As Mr. Hendry pointed out, and I know Mr. Walker personally as well, I know they visited, Superintendent Ritz visited, Senator Donnelly has visited, Robert Enlow from the Friedman Foundation has visited our school, and it is one that we're very proud of. It's a school that gets along with the public school. Dr. Watkins and Dr. Egan have a collegial relationship. It's a school we're very proud of. It's why it has a large waiting list to get into, and we simply don't believe that it warrants the Fs and Ds that it's has been given under the atypical configuration. I would request the board hear a belated appeal on their behalf. Thank you.
Thank you.
May I ask a question
Brad?
of the gentleman? Sorry.
Yes, I'm sorry.
You may have said this, I'm just trying to wrap my head around
Sure.
the two presentations together. Explain to me again why the appeal wasn't filed within the window.
It was simply that neither Dr. Egan nor myself was aware of the announcement of the window.
Okay, thank you.
Yep, thank you.
I have a question.
Yes.
Thanks for your presentation.
Sure.
My question, are you claiming there's a miscalculation of the formula, or are you indicating that there's a misapplication of our policy, or something else?
I think, and Dr. Egan, I think, spoke to this, part of the information, and I think it depended on the year. I mean, you had 1 year where they only used the 10th grade ACA. You had another year where they didn't apply the different, so I think it may be a misapplication, or it may be simply the policy as a whole.
So it's not a misapplication of what we've already adopted.
That's
It
correct.
is another wrinkle potentially in our definition of atypical school.
That's exactly right, yes. Thank you. Thank you.
Dan Scott?
Good morning. My name is Dan Scott, and I worked at DOE from January 2008 through May of 2012. Specifically at DOE, I was on the accountability team, and one of my major responsibilities was to work with the A through F working group, as well as Jeff Zering, then Molly Chamberlain, then John Gabera, on the creation of the current A through F model, as well as working with Michelle Goff, now McGowan, to actually convert that model into the state rule that we currently have. I've been asked to speak to you today regarding the weighting of these combined schools, the elementary, the K-8 model, and the high school model. When we designed the current model, we looked at two components. One was the K-8. When we decided to settle upon weighting, we looked specifically at just the grade levels that actually had some kind of measure calculated or factored into the grade. So therefore, the K-8 model, we only look at grades 3 through 8, because those are the grade levels in which there's actually measures in place. At the high school level, it's a little more complicated because we don't have annual tests. However, at the time, we decided that, with judgment from the U.S. Department of Education, that the 10th grade ECA calculations really represented what happened at that school from grades 9 through 10. And with that, the graduation rate and college and career readiness rates were representative of what happened in the upperclassmen years, the grades 11 to 12. With that, obviously, graduation rate encompasses all 4 years. However, with Indiana having a dropout age requirement of 18, the vast majority of dropouts in grades 9 through 10 do get claimed or picked up at another school. So really, you're looking at the ECA takes into account grades 9 through 10 performance, and college and career readiness and graduation rate take into account grades 11th and 12th. So with that, there's been some concerns lately, as the two groups before me spoke, as well as a couple other charter schools, about the weighting of grades for this combined model. Specifically, how do you weight and what grade levels do you include in the weighting for this model? Currently, it seems that DOE has decided or has made the decision that for these combined models, even though you may only have 10th grade ECA as your only performance measure, the grades 11th and 12th grade should be included. However, if you look at the model and look at the original intent of the model, it should really only be grades 9th and 10th grade. Including grades 11th and 12th grade, where you don't have any performance measures included in the overall grade, it would be the equivalent of including grades K through 2. So basically, I just wanted to speak to you today to clarify the original intent of the model, because I know there's been a lot of turnover the past few years here. I want to make sure that you guys had all the information in front of you. Thank you.
I am not aware of the action that's wanting to be taken under atypical schools in our business item. So I'm looking to someone to talk about what our action is.
Let me pose a question.
Sure.
Because we had, at the last board meeting, a motion that was approved by the board to treat a series of schools. I had had conversation with Danielle, and I believe there was going to be some follow-up on that, and I've seen a couple different emails. I'm trying to reconcile what was sent to the board just prior to the meeting, because there was a couple memorandums clarifying letter grades versus the 60-plus schools that we talked about last time that were, because of the way we looked at Carpe Diem last time, how that would have potentially impacted. Can we get clarity from the board on where we're at? Are we going to take those all together, or are we going to deal with atypical separately, I guess is my question. I think that's why it was on here as an agenda item.
I'm wanting to have some clarity on what the action is that we're taking under atypical, because we listened to the appeals last meeting.
During the conversation with the board last month about atypical schools, one of the board members asked, are there any other schools that are configured similarly to Carpe Diem? Debbie's response was 72. Now, during the time between that board meeting and this board meeting, we have been in conversation with the DOE staff to identify those 72 schools. They identified the 72 schools, and Cynthia looked through those and found that 41 of those schools had received a null grade, which meant they didn't have sufficient data to give them a grade. 19 of those schools did not qualify because they had sufficient data points. They weren't atypical. Then that left 12 schools. Of those 12 schools, we asked for additional data and did finally receive that additional data. And that additional data was about the cohort in the 12th grade and how many students were in that cohort. So we could really look at were they atypical or were they not. At that point, the DOE staff then on Monday brought to us that they had looked and identified 8 of those and said that they had applied a new model to them as a result of our conversations, and that left 4. Those 4 were the 4 that you received an email from Sarah Rozier yesterday, and with each of the models identified so that you could, because we looked at them and based on our conversation configured like carpe diem, considered that the board would want to consider them as atypical schools. So you have the models, all of the models that are available, and the grade that would go with those models, and the action would be to place a grade for those 4 schools. That, because our understanding of atypical is that they fit the same model as carpe diem.
So for clarification, to the board members, the term atypical to the Department of Education has been the same schools that have been in the groups that were done with the Grue-Sheldrick report. We have not changed our definition of how we look at atypical schools with being an actual grade configuration that is not written within rule. So I know there's been a lot of papers going back and forth between the department and the State Board of Education staff regarding this. So last evening, I believe we got these 4 schools from you, and I'm still unclear as to what the action is supposed to be. We applied at the department, we applied the very same logic and calculation that we had applied to the schools and that we notified schools similar to carpe diem last year. So from the department standpoint, we've applied the very same metrics. So I guess I'm still unclear as to what our action might be.
I think I can bring some clarity to it.
Okay,
First of all, I
Brad.
appreciate the fact that staffs did go back once we finally got data shared and looked at this and examined it, because last month, once the board took the action it took to basically look at carpe diem the way it did, I think it created an obligation to go back and look at all the schools. That's why we started at 72, and I appreciate that you whittled that down. Now we're at 4 schools, and I think the conversation that's very appropriate for the board goes back to the very thing I talked about in my opening comments. I think the board has an obligation. We've got 4 schools that clearly did not fit what the rule originally envisioned. So I think it's very appropriate for the board to take a look at the models, use all the available data. I guess I would have a question for our council that I just want to make sure of, because I'm not aware of a statutory definition of atypical. Atypical to me would mean is that the statute or the rule did not fit the situation, and the board is left to figure out what is reasonable, what is fair under due process for these 4 schools. And so I would submit that the action before the board is to look at these 4 schools, make a determination which model we're going to apply that presents a grade that's reasonable and relatively accurate to what's actually going on in the school before we finalize these grades on these 4 schools. So that would be my take on this action.
So you have it before you, if that's what we're proceeding with as the action. So you have these 4 schools that are listed, and you have an elementary middle model. There's just the high school only. Then there's the grade 10 weighted, and there's the grade 10 weighted, 9-10 grade weighted, and then there's the grade 9-12 weighted grade, of which is how the department figured it. So I want to make sure that you understand that the calculations that we put forth was the last column.
And Madam Superintendent, if I could I ask a question of our council, please?
May?
John, can I ask you a couple quick questions?
Madam Chair?
Just one moment. We have a question for our council. And then I'll call on you, Tony.
John, I have two questions. The first one goes to this definition of atypical. The department's applying a definition of atypical. Am I missing something statutorily? Is there something that says this is when you know it's atypical, or is there a definition given, or is it simply a term used to reflect that the rule does not address the situation?
The term atypical is defined in the board's emergency rule, 14-348, that the board adopted in August. It's not defined in statute, but under the board's rule 1438, it shows that an atypical school has at least one of the two following elements. It either has an atypical grade configuration, meaning that it's physically lacking, say a grade 12, or it has all the grade configurations. It has a K through 12, but it has atypical data for one of those grade configurations. And that's under section 2A of the rule, which the board discusses atypical schools as either those with atypical grade configurations or data, and not just atypical grade configuration. So that's where I would point you for a definition of atypical schools.
Okay, so I'm working on the subject because basically the board took action. We're looking at 4 schools that are atypical from the board standpoint. As I'm looking at these, last time we met and we looked at Carpe Diem, we took a specific computation model of elementary, and the logic behind that was that's where the greatest data was. That's what we had to look at. As we're looking at this, is there anything you would advise the board as how we should evaluate the 4 that are in front of us? Because staff has given us, by my count, 1, 2, 3, 4, 5 scenarios under which we can look at them. And I think where I'm looking for some legal guidance from council is it would seem to me that the obligation of the board is to not only apply reasonableness, but apply wherever we have the greatest amount of information, greatest amount of data on the schools, and where we believe that grade is most accurately reflective of that school. If I'm wrong on that, I'd like to know what you would recommend in terms of what are some boundaries we can use, because we're currently, once we're into atypical, we're basically now operating under some degree of common sense and reasonability.
Well, my impression is when the board addresses these atypical schools, it takes combinations, elements of the other models, and applies them. So it might just apply an EMS model if the school has a K through 12, if the school is lacking a 12th grade data point, or it might apply the small high school model if the school has a K through 12, but it has an insufficient grade 10 cohort. I think looking at the data points is probably the most important thing you should do, and that is, as far as I can tell from reading the Grew-Sheldrake report from October 2013, it's consistent with Grew-Sheldrake. It's also consistent with, I think, the board and DOE's past practice, and it's also consistent with how the courts would interpret Emergency Rule 14-348 were they to have an opportunity to do that. If you look at Grew-Sheldrake, it concentrated on incomplete data sets, missing high school data, a lack of high school metrics, and this is all pages 13, 15, and 17 of the Grew-Sheldrake report. In fact, there's a table in the Grew-Sheldrake report at page 13 that shows 4 schools in 2012 had grades K through 12, but were treated as atypical by the DOE then because the schools were missing high school data. Grew-Sheldrake said this approach was plausible, fair, and consistent. Grew-Sheldrake never said or indicated that an atypical school was only a school lacking atypical grade configuration only. And so I think the board's interpretation of Emergency Rule 14-348 is consistent with Grew-Sheldrake and with the DOE's past practice. I also think it's consistent with the board's recent past practice. At the September 2014 business meeting, a motion was made to use any available combination of the EMS high school models for atypical schools. Now that motion was amended to require the DOE to run both the EMS and combined models so the board could have all available data, and the DOE agreed to do this. And the motion was amended a second time to allow schools to challenge the data used to calculate their grade and the grade itself, and to challenge the grade even if the data were correct, if the grade did not fairly represent the school. And the DOE agreed with this too, and that motion was passed as amended. And that's at pages 12 to 13 of your September 2014 minutes. So this interpretation of 14.348 is consistent with board's past practice. And finally, it's consistent with how a court would interpret Emergency Rule 14.348. This emergency rule is what is known at law as a remedial rule. And what that means is that this rule provides a remedy. It's a fix-it rule. And remedial rules or fix-it rules are given very broad interpretation by the courts. This is so the rule can be given maximum effect to remedy the problem it was designed to address. Some might argue that the emergency rule more narrowly applies to just schools with atypical grade configurations only, but I think that would be incorrect for two reasons. First, it would ignore the plain language of the rule, which clearly applies to both atypical grade configurations and atypical data, but it would also violate the law that says remedial rules must be read broadly. So I think to go back to your original comment, I think you're on the right track. This rule was designed to broadly address the issues and problems faced by schools with atypical grade configurations and atypical data, and I see nothing inconsistent in your application of it to Carpe Diem as compared to what Bruce Sheldrake said, what the board has done in the past, and how I think a court would interpret that rule if it had an opportunity.
So Brad, do you have a motion?
Well, I'd like to have,
Oh, wait, there's
I'd like to
Tony.
have some discussion.
Oh, Tony, wait, Tony, I forgot. Go ahead.
Yes, thank you. I just want to say, I think it's wrong that a school could be penalized because it does not fit in with our established assumptions on configuration. And I don't think a cookie-cutter approach to all these schools is going to work. I mean, the fact of the matter is we have a lot of different configurations that have this problem, causing this problem in the first place. And I think there is room for discretion here within the law as to how we apply the formula to schools that don't neatly fit. So I would hope that we would consider a motion to review all of the uniquely configured schools and to look at them individually and see how best to apply the formula to their unique configurations. It's just, I would hate to think that we're going to have schools out there that possibly are going to have a letter grade reduction just because they don't fit in the way we say they should look. So I'm hoping that we take care of all of the schools that are in this category through individual review and discretion to apply the formula to the individual configurations of those schools. Thank you.
And Tony, I think that's why we have these 4 schools before us. There are 4 schools.
Right,
Well, there are other ones.
There are 4 schools that fall within the definition that council just gave. 4 more.
I'm concerned that there may be other ones other than those 4.
Just to clarify, Madam Superintendent, if I could, because if I'm understanding, I agree. I think we are down to just these 4. If I understood, and Tony, I know you can't maybe not see his staff out of line of sight, but I know that board staff and department staff looked at these jointly and worked through, and I think we said some 41 Renault, anyways, we worked it down. I would love to I'd like to hear from the colleagues. I'm happy to bring a motion, but I mean, one of the 4 is not going to be affected under any model. I mean, that's very evident. It's really 3, even though we probably ought to take action on 4, but I don't know what the pleasure is of the chair, but I think there's other colleagues that want to weigh in here.
Oh, sure, I don't care who weighs in. Dan?
I think
Fine. I'd be pleased to weigh in, but I see Bob wanting to make a comment.
just wanted to make sure that the board also addresses the HAST appeal and Carpe Diem, make sure that those are included in your decision-making. And on a more general note, just be aware that all the school placements need to be done today as a matter of law.
Could you comment specifically about, John? Could you comment specifically about what we heard during the general public issue from the Hammond School and what we are and are not entitled to do in that, with respect to that school?
Well, your discretion is broad under Rule 14-348. The way I would suggest you analyze the situation is ask two questions. First, does this school have all the grades required by the model? And if the answer is yes, go to the second question. Do all those grades provide the necessary or available data required by the model? Now, if the answer to either one of those questions is no, then I'd suggest under the language of your emergency rule, you have an atypical school, and you have a choice now to make how to address that. But the decision how to do that has to be yours.
May I make comment?
Yes,
After
Dan.
listening, reading the material, first of all, I was disheartened at all the delay in information movement, but that's already been addressed. Fairness, what did you really earn? You can't penalize schools for something they can't do. Legally, board responsibility, it's pretty clear what we need to do here. We have some atypical schools. And frankly, I think a lot of them are doing pretty good work. And we ought to just try to be fair in the spirit of due process. You don't penalize institutions that are working hard and doing good things with children just because they're atypical. And so that's what the board's supposed to do. I think it's what it's done in the past. We even had a big review after the first grading, and we had experts look at it, fair and plausible. And I think we ought to stick with that, and we will grow in our ability to do accountability and grading in the future, but right now what we have is pretty decent considering it's a new initiative. It took bold action. So everything I've heard, it's pretty clear that we have some atypical schools. The board needs to recognize it, move forward in a professional and fair manner. I know it's within the law to do it.
That's correct.
Schools need to receive an accurate indicator of the quality through our A through F grades, so this is an important discussion. I'm concerned that the board in a public meeting is going to go through all the data and so forth, but there seems to be one question: is the school atypical or not? That's probably a staff question to come back to us and have that answered. Staff could look at it, ask those questions that you just asked, and then if they are an atypical school, then our staff could apply the particular model. So my hope would be that we don't spend the next 3 hours going through each school, but we refer it back to our staff to take a look at the data and to give us an indication. I know you sent us a chart, and I'm looking at the chart. It's slightly confusing, so maybe you've done that, and you just need to alert us to which column that you're recommending, because there's about 5 grayscale columns that there's no indication beyond the chart which one is the recommended. So maybe someone could come forward on our staff.
David, I think what they told us that the two staffs got together, started at 70-some, and we have it now narrowed to this tight group. So I think they have done what you've requested. If I'm wrong, correct me, but I think we have an agreement on the group of atypicals.
You're correct.
I believe we're proceeding as we did with the atypical at the last meeting, in which we were given the information, and then we decided, based upon the appeal, as to how we would be weighting the grades.
So my question is, out of those, on that chart, which ones are you recommending, which column? We're talking about these 4 schools, right? So which column are you recommending we adopt those grades?
I should probably yield to our data expert, Cynthia Roach, at this point, with your permission, Madam Chair.
Yes.
Quite honestly, I hesitate to give a specific recommendation for any one school purely because I think you need to do, as John indicated regarding, look at each of the different possibilities and evaluate the school based on what you think is best for each possibility. And some of that varies, including all data points, depending on the weighting, can bring a school from a D to a C, depending on the weighting. On the other hand, you have decided to evaluate one of the atypical schools purely by leaving off the high school model and only looking at elementary. So I guess it's also your purview to do only elementary or only high school, or a combined approach. But I'm hesitant to give a specific recommendation.
I think it's important to treat all schools that are similarly situated the same way. So regardless of the name of the school, regardless if their grade's going to go up or down, there has to be a set of criteria that we use and say this school and that school are similarly situated, therefore we should use the same model for both of those. And so I'm trying to figure out which schools fall into a category that is similar.
With Carpe Diem, these are all
Right.
similar to Carpe Diem.
I'd like to speak to that if I could, to my colleague's point, because I appreciate you're not wanting to weigh in on that, but I'm looking at it, and to me, in this situation, I'm looking at the enrollment count. And I come back to what we said last month when we looked at Carpe Diem, and when I look at grade 3-8 enrollment, that's where the critical mass of students are at. That's where the most students are at. That would seem to me to be the place that I'm going to look. It doesn't necessarily generate maybe the favored grade that they want, but if I'm going to seriously try to align a grade with an actual reality, I think it's a reasonable argument to say, where's the critical mass of students? And it seems to me like the bulk of them is in grade 3-8, and if that's the case, I think it would move me to look at the elementary middle school model, which is I thought what we said we were going to do the Carpe Diem last time, but maybe we didn't take action. And that is also a question for staff is I know I brought a motion to table this to the letter grades. All I'm wanting to clarify on this action is, my thought was by taking action on this is we'd resolve this and then include whatever grade model so that when we approved all of them, it's done. So that's kind of the logic where I'm going. If there's a motion needed on this to resolve this, and we get that done ahead of approving all the grades.
To that point.
You did receive from the department a summary. It had 4 grades on it. And Carpe Diem, there was no grade change, but we did take action to use the elementary middle school data only.
And I think that's where, Madam Superintendent, that's where I'm going to be heading with a motion, but I know there's other folks that want to ask questions.
Well, to your point, to apply the elementary middle only, the rule allows for the growth model only to be applied, which you do not see any grade based on growth model only, purely because I don't have access to that type of thing. So the question could really be, if the growth model only would be made available for these 4 schools as well as Carpe Diem, what would the grade be? And I think that's a different question.
And I will tell you that the department, since the conception of this A to F, has not offered the growth model option to schools that have more grade configuration than just elementary middle, the actual grades they serve. So that has not ever been an option to any school if it had more students in grades above grade 8.
Question.
You may.
Deb, I see you've come to the front. Would you by chance have a recommendation for us out of this?
Thank you, Deb. And so, since Deb is going to speak, the very last column on that page is how the department has calculated the grades with the direction of the board last December, when we dealt with the same kind of issue that we brought to you from the department because we wanted you to weigh in on how we should calculate these grades.
So I think there's a few things that we've been discussing. We might start with HAST. Under the HAST, that school was identified in the original list of 7 schools as atypical. So I think the conversation is simply, will we accept a belated appeal for that school? Concerning Carpe Diem, growth-only model, the department does not consider that applicable for the school because they do have high school grade levels. Therefore, we do not consider that a growth-only. Second point around Carpe Diem is if the growth-only model option were provided, the school would have sufficient data points to calculate a growth-only model. Therefore, the no grade option should not be applied for the school. In addition, if the growth-only model option were provided for this school, and if for some reason we could not calculate a growth-only model, excuse me, grade, but we could calculate an EMS grade, we would not provide an option to the school to select no grade. We would apply the EMS model. Therefore, under Carpe Diem, we do feel that that should be denied. Okay. In continuation? Sure. Now, getting into the other schools, the 4 schools identified as an expansion of the atypical language. The difference between these schools from Carpe Diem is, if you'll note on this sheet, the inclusion of the high school data is a benefit to most of these schools. Whereas for Carpe Diem, including the high school data actually pulled the point value down. Therefore, we would recommend the continued use of the high school data for these 4 schools, included with the 9-12 enrollment, which is the final column available on your sheet. Correct. And that is the information that's already been presented to the school as well.
In September, we had a discussion in Fort Wayne, and it was discussed a little bit that we were going to select the best model that benefited the atypical school. Was that enforced in every case?
So we did not select the best model. We allowed that to be opened up to the appeals process and allow schools to appeal. We have received appeals from a few of the schools, which we did consider at the last state board meeting. However, as Hammond Science Academy noted, they have not appealed until this point to have their grade considered as atypical and possibly use the elementary data only for their grade calculation. Since their grade was calculated as a combined model, the information that was presented to them is the full elementary calculation as well as the high school calculation and then overall combined information. So as your speaker noted earlier, they do have that information as far as what their elementary grade is, what their high school grade is, and then finally the overall grade that the DOE applied to the school. So again, specifically around HAST, I think the question is, given the appeal was submitted outside the appeal window, should that be heard, and should they have that advantage of being considered as atypical at this point?
So I'd like to break this down to a couple pieces. Because the department is responsible for figuring the next round of grades using the same model, using the same A to F model. And so I guess my first motion that I think we should consider is these 4 schools are considered atypical by the board, so that we are clear that we are, first of all, placing them in an atypical kind of situation. And then we should then proceed with what it is that we want to do with them. So do I have a motion to place these 4 schools in atypical status?
So moved.
Do I have a second?
Second.
Any more discussion? Roll call, please.
Yes.
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 Yes. Second motion. Brad?
Yeah, I would actually move, Superintendent, that with respect to all 4 of the atypical schools, I'll explain my logic, is that given that the concentration of enrollment represent the greatest number of students in the schools, that we would apply the elementary middle school model to all 4.
Is there a second?
I'm sorry, what's the motion?
He'll repeat it.
Tony, the motion would be, given that the enrollment is greatest in grades 3 through 8, that the board apply the elementary middle school model in determining the letter grade on the 4 atypical schools before us.
Is there a second?
Second.
Any more discussion? Yes, David?
Is this a precedent-setting decision on the part of the board, or is this within the law and within our own rules? Is this creating a new rule or a new precedent or interpretation, or is this within our authority to do?
Madam Chair.
So is he asking, you're asking counsel?
Well, yes, I'm asking counsel.
Okay, and then,
Thank you.
so before you begin, John, because the department is responsible for calculating these grades. So, and it was my firm belief that last December we decided to calculate the grades according to the appeals we brought to this board to weigh in. And so we calculated the grades with the combined models as we did. So I just want to say that each time we have a conversation about how to calculate grades, it changes what we do at the department in notifying schools on how their grades are going to be calculated the next year. And if it's not, then what we need to define, which I think we've just done, is the whole pool of atypical, which now by emergency rule will come back to this board, could be appealed, okay? And that's where we would move. But we also have the small high school issue, that's what we brought to you last year, in which we went ahead and said, okay, here's how it's going to be calculated going forth. We sent out letters. We have to make sure our schools know how it is that they're receiving their grades. We have an obligation to let them know how they're going to receive their grades. We have to do initial calculations of their grades. So we have to have the department, when we feel like we have direction on where to go, we act upon that. And I have to act upon it because I have to notify schools how it is they're going to receive their grade. These are very important pieces when we start labeling schools. And so we have a system currently that has so many configurations and so many different ways. It's flawed in essence, and on the new one coming forward will not have to deal with this in this manner. But I need clear direction. I appreciate your question because I thought last December I had very clear direction from the board as to how we were going to calculate these grades. So we did so, and now we're here talking about what does atypical mean again. And that's okay as long as I know what it is going forward, because I have to let people know here's how we're going to calculate grades.
It is appropriate for the board to consider the administrative issues it raises when you deal with these. Obviously, the DOE has limited resources and person power, so I think that's an entirely appropriate point to raise, and it's an appropriate thing for the board to consider as it addresses these things. To get to your question, Dr. Freitas, is the board setting precedent? Well, in a certain sense, yes. When it is confronted with a novel fact situation and addresses that, it is establishing a kind of guideline for future similar situations. I would submit that the board has not been presented with every possible novel configuration or atypical configuration that could arise under these schools, and you have to anticipate being presented in the future with fact patterns that you can't anticipate today. There was I think in a September board meeting, and I may be wrong about the actual date, but there was a motion that tried to impose a kind of one-size-fits-all remedy to the atypical schools, and the board rejected that. And I think that's probably the wiser move. You're going to have to, at least for a time, take these on a case-by-case basis because you can't predict every grade configuration. And Bruce Sheldrake said that when it came and testified before the board, said you just can't anticipate 93 different possible permutations of atypical schools. So I think, yes, you are setting precedent. I think you have to take it carefully on a case-by-case basis and be very careful that you're treating like schools in a like fashion. But if you are presented with a novel fact pattern, not be bound by the solution that you another school. It may or may not be appropriate, and those novel fact patterns deserve a look with fresh eyes, if you would.
John, just a quick question, since you brought up the Grusch-Sheldrick report. Did it not also say that because one school was not treated differently and that the same manner of calculation was applied to all of them, that's why the finding was as it stated in their report?
Yes, there were, at that time, there were approximately 16 or 17 schools that fell into a similar fact pattern, and they were addressed consistently according to Grusch-Sheldrick.
And that's how they said they should be addressed consistently.
Right.
So I just like to say that again, that from the department standpoint, when we get guidance from the board, when we bring things for appeals, we actually do feel that that is how we should begin to calculate these types of scenarios. So the ones we have before us today, we calculated in good faith, decisions made last December. They are before us now, which is fine. And we need to decide whether we're going to apply the same logic to all of them or whether we are actually doing them separately.
I'd like to speak to that because I think we need to draw a distinction between setting a precedence and creating de facto policy. The board adjudicates things all the time. It sets a precedent. It doesn't create de facto policy then for the department to send out guidance to all the schools per se. When we're dealing with due process, I think it's reasonable what the superintendent is saying, that the department has to have some guidelines to go by, and we have those, and to the extent that the rule is clear, and I agree with the superintendent, I look forward to fixing the rule and addressing some of this stuff. But I would hope that when the board is at this level, which is the last step in my mind in procedural due process, where a district or school is trying to get relief, if the board does its due diligence and weighs all the evidence and comes up with a conclusion, I hope that's not interpreted by the department as de facto policy, but simply a response to a specific situation. Does that make sense?
Yeah, and I think that's probably the better approach. That's the case-by-case approach, because these situations are fact-sensitive.
The precedent we're setting is that we use judgment and provide leadership so things are fair and run well.
Sure.
That's the only precedent we're setting.
Sure, and that's it. That's a consistent approach to each one of these.
So before us, David?
So what we're saying is, and this is really good to clarify, not only for DOE, but for schools out there, if schools have a similar fact pattern, is what we're saying, then they will all be treated equally. If there's another school or a group of schools that have a different fact pattern, those schools need to come to us, and we will look at how to treat those particular schools. We don't know if there are other schools with a different fact pattern, but at least for today, these seems to fit into a specific fact pattern, therefore we should treat them the same. Is that the rationale?
Correct. So if you have a school with a K through 12 but it lacks a grade 10 cohort, that's factually different than a school that has a K through 12 but maybe lacks a sufficient graduating class to develop available data.
So as we make these decisions, then we can notify schools to say, if you fit this particular fact pattern, this is how you are going to be calculated. Your school grade's going to be calculated. Is that correct?
The law also permits schools to appeal if there are any factors that they think, objective factors they think are significant. They can
John,
still
let me
bring those.
clarify. So in September, I have to have this totally clear because I have to be sure my staff knows what to do. So in September, we said for the atypical schools, we would run the combined model, and so that the board could see the elementary and middle separate from the high school, and then view each one of those separately. So going forward, the department would continue to calculate the combined model and bring the atypical information to the school board. Did I state that correctly?
I think so, and I think
Okay.
also
I just want to know how we're treating them, making sure that I know how the department's going to calculate the initial grades.
And I think it's appropriate for the DOE to seek guidance if it finds a fact pattern that hasn't been addressed.
Oh, we did that even last December.
Sure.
Absolutely no problem. We did that already.
I think if you follow that
So
procedure.
we have a motion before us in a second to apply the elementary middle school model only to these 4 schools. Any more discussion?
Is there a reason we're not naming these schools right now?
Is there a reason we're not what?
Naming these schools? Just for the members of the public who may be watching?
We can name them if you wish. It wasn't given to you in that way. I have the names.
Why don't we go ahead and, I think we should share that before we vote on it.
The first one is Horizon Christian Academy. The second one is Columbus Christian. The next one is the King's Academy. And the last one is Lighthouse Christian Academy.
Thank you.
You're welcome. Let's take roll call.
Yes.
Yes. Yes.
Yes.
Yes.
Yes.
Yes.
No. Motion carries.
Madam Chair?
Yes. Yes, Tony?
I'd like to address the issue regarding HAST.
Regarding what?
Passed.
Past?
HAST,
Okay.
correct. The HAST represented to me that they were informed earlier this year by the department that this was not going to be appealable, and subsequently, it did become appealable. But I think there was some confusion with regards to the school leadership around that issue. Hence, they did not formally and timely appeal. But based on the fact that they may have received some erroneous information regarding that, I would ask that I move to accept HAST as an atypical school for the purposes of this accountability. That's my motion.
Tony, I will say that everyone is notified of the appeals window time, like every school. So we have not taken appeals outside of the window. Is there a second?
I'll second it.
Is there discussion?
I just want to ask clarification on the motion. Is the motion that we're basically allowing them to appeal after the fact, or that we're treating them as atypical?
Well, we will have to
Because
do
I think
that
those are two separate
first.
things.
I think we have to do that one first.
Okay, but I thought I heard Tony's motion as to treat them as atypical. I'm thinking in my mind, the logic should be that we first agree to take their appeal since it's beyond the appeal window, and then determine how we want to evaluate them. I guess I'm asking for a friendly amendment to the motion to bring clarity on that, because if I heard the motion wrong, I'll apologize, but I thought the motion was to treat them as atypical. I think the real question is, are we going to let them appeal?
There's another question I have.
So now I'm totally confused. So I've got Tony with the motion. Tony, you are you suggesting that we listen to an appeal outside of the appeal window?
I'm suggesting that that HAST be permitted to appeal based upon their atypical configuration.
Okay.
Because on their representation, they received erroneous information about this issue being appealed.
May I
Well,
ask?
I would take objection to that, but you are asking for the board to consider the appeal at a later date, because we don't have any information here today regarding.
Oh, yeah, I'm not asking to rule upon it today, because you have to figure out how to apply the formula to their model. But I'm just asking that that process be initiated and that they be permitted to make a case as to their configuration.
May I ask a question?
And so,
May I ask a question?
quite frankly, I have to really talk about the ramifications of this first,
May I ask a
from the
question?
department's standpoint first. So if we vote to listen to this appeal on atypical, then what are we doing with all these other schools that we just did?
Madam
May I ask a question?
Yes, Dan.
Thank you, Superintendent. Last meeting, we had schools that had improvement in IB scores. And I think they called Bernice, if I remember right, and they told them you can't appeal that. I'm just wondering how many schools have called and asked if they can appeal. We're told they can't appeal. And if we take this appeal late based on the department telling people they can't appeal, and now we find out they really could appeal, how many appeals are we going to open up? Does anybody have an estimate for that?
Dan, first of all appeals were heard and all appeals were acted upon. All of them, even those who came back to us.
Were any schools told they could not appeal and then just walked away and said, well, it's not appealable? Because that's what Haas' claim is, correct? They were told they couldn't appeal it?
No.
No? That's not
No.
Is that what?
They have not appealed.
Didn't they ask to appeal and they were told it wasn't
No.
appealable?
No, not at all. We would not do that. No.
Is that what I heard or no?
I think he's...
It's okay, so in essence, you were told you couldn't. That's what I was trying to establish. And do we have a lot of those cases?
Yeah, go ahead, Deb and Danielle.
The DOE does not tell schools that they may not appeal. We provide information that tells them about the appeal window, that any school may appeal anything that they think is incorrectly calculated. In Haas' case, as they stated before, they did appeal twice. They appealed in 2012 because their grade calculation only included elementary, middle school, and they felt it should include the high school data as well. That appeal was denied at that time because the policy in 2012 was to use elementary, middle school data only for those schools. In 2013, the policy was changed to use the high school data as well as the elementary school for the atypical schools. Therefore, they did appeal again in 2013 to not use the high school data, and that appeal was denied. In 2014, they did not submit an appeal. They did contact the department to find out if the 2014 graduation information would be included in the calculation for 2014 grades, and the answer is no. 2013 graduation information is included in 2014 grades. For 2015, the 2014 cohort data will be used for grades.
It's always a year behind.
Again, so the clarification over the summer was what specific data points would be included, and the information the department provided back was combined elementary as well as 9-10 data would be included in the grade calculation for 2014. And again, we do not tell schools not to appeal. It's definitely their right to appeal.
So council, if you could address us, because I think the main question is, if we accept this appeal, what does this do for the appeal process, not only for atypical schools, but perhaps, I honestly don't know the ramifications of this. We've not ever taken an appeal after the window's been closed.
Let me break it down into a couple of parts. First, the desirability of having a cutoff date for appeals. You can't just indefinitely accept appeals because the system grinds to a halt. So there does have to be a cutoff date. The next question is, in this case, the school has represented that it received information from DOE that led it to conclude that it did not have an appeal. And on the other hand, you have the DOE stating that it's not its procedure to tell people they cannot appeal. So I think to analyze this specific situation, you probably have to ask yourself, was it reasonable for the school to rely on the DOE statements in the way it did and not appeal? If it was, then you might want to consider making an exception in this case for that reason. But if it wasn't reasonable, if you find that a person couldn't reasonably conclude from what the DOE said that they don't have an appeal and that people should understand they have an appeal right no matter what, then it would be appropriate just suggesting this is how you think about the issue. Now,
So how does it affect the four schools that we just placed grades?
the four schools, it would affect them if they were to come back and make identical arguments, then you might be obliged to treat them in the same way. But I don't think, if you frame this issue very narrowly, as I just did, it doesn't open a door for everybody simply to reappeal their grades because somebody else got to appeal. In other words, there has to be substantial justification on a case-by-case basis for somebody missing an appeals deadline. The deadlines have to mean something.
So these four schools that we have right here before us, who were not on the initial list, did not have the opportunity to appeal, didn't even know they were atypical, because we've always treated them in a manner with the small high school calculations.
Point of order. How is that germane to the motion on the floor,
I just
because the
wanna
motion is
know.
whether or not we're going to allow an appeal in this instance, and I think the discussion should, if I follow rules of order, should be limited to the motion on the floor.
That's okay. I'm just asking a question if it has any bearing at all.
I think the question you raise is a very different issue, and I don't think it's affected by the decision you're making here. The question with respect to the four schools, looking in the past, for example, embargo data were released to schools and they were notified of an opportunity to appeal, and it's kind of followed that procedure. This is a very different situation. This is somebody who was in communication with the DOE. They believed they were told something that led them to believe they didn't have an appeal. And so the question before the board is whether they reasonably relied upon what the DOE said to forfeit their appeal. And if they did and were prejudiced by that, then it might be
So
appropriate.
it would have no bearing on being an atypical school. That was the reason for my question.
No, this is something that could happen with typical schools or atypical schools, this sort of situation we're discussing right now.
We have a motion,
Madam
and I
Chair,
think we had a
if I may.
second. Yes, BJ?
I know that the principal from New Tech Institute is here. I'm not sure if now is the appropriate time, but I think there may be some correlation with the process with Tony's motion. I don't know if now is the appropriate time for him to speak. Hear from him, I would like to, if we could.
That is under the next item.
Okay.
Oops, so sorry.
Madam Chair, I would just like to say on the legal issue, I think past the situation is distinguishable from the other schools to the extent that they were apparently deprived of their opportunity to appeal directly based on misinformation from the department.
We have a motion. Did we get a second? Any more discussion? So the motion is to accept an appeal from HASP and to then review that, I guess, in the future. So the motion is to accept an appeal.
Yes. And I don't want to prolong this, but may I ask counsel one more question?
You may.
Thank you, John. The point is, in these memos, it made it pretty clear. They didn't say you may not appeal, but it said you may not appeal, basically, because it said the information. So it wasn't appealable. So then we can deal with this situation, and what I was trying to understand, what will this bring us in future meetings, and what will be required of this board then if other people produce memos that was told essentially they couldn't appeal? What's our obligation legally, due process, and fairness going forward then in the next subsequent meetings when people come to us? Does any other board members have that question in your mind? And I'd just like to know your thoughts on a legal basis and good practice for boards.
Two things. One, I think the law requires you to give them some sort of meaningful review. It doesn't require you to grant them, but it requires you to give it some sort of meaningful review and then make a decision. Because people do have the right to appeal by statute their grade placement for a variety of reasons. The The second thing, and this getting back to, Madam Chair, your question about the 4 atypical schools, I should also point out that in that case, the emergency rule really governs that procedure there right now. So that may alleviate some of your concerns about past practice, future practice, because right now we're operating under Rule 14348 with respect to atypical schools. And that requires the data to be provided to the State Board of Education, and then it'll make the final placement decision.
And so I just want to be clear about the statement that was presented from the department, because it really says the school was assessed under different models in 2012 and 13, which is true. The first time they were assessed was under an elementary middle model. The second time they were assessed was under a combined model, and we notified all those schools as to that. Appeals were submitted each year concerning which model was being applied. Both the 2012 and 13 appeals were denied because the application of the model aligned with policy as defined for the applicable school year. That is a true statement. We did not say anything about this year's data or appeal in any way. We were responding to information regarding the denial of the 2012 and the 2013. So I just want to make sure that we're clear about what it is the department did.
Right, and it's also should point out that the vote taken in December 2013 was factually materially different than what's being presented
Correct.
today.
They were treated differently, and we notified them. We did what it is this board directed the department to do. So we have a motion before us to hear an appeal for haste, and we have a second. So roll call, please.
No.
Yes.
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 While I'm sympathetic, no.
Yes.
Yes.
No.
No. Six four to hear the appeal. So the school will be able to submit an appeal. So now we need parameters, like submit it when.
Can I ask a question?
You may.
How many days were open for the appeal process?
Deb? 10 days.
I'd say 10 days.
All right. The school will be notified of their date, time within 10 work days, is that correct? To submit their appeal.
John, are you trying to speak?
I think, if you don't mind, I will take a roll call on that so that the department is very clear about what it is that we're doing. So I'm going to move that the department send a notification to haste to submit their appeal within a 10-day window established by the department upon sending out that letter. Do I have a second? Any more discussion?
Can I hear from council?
Oh, council wants to address this?
Madam Chair, this appeal needs to be decided by November 15th because that's when the emergency rules expire. And it's possible the board loses its legal authority to place the school after that date. So I would recommend some sort of expedited appeal process that would allow this to be concluded before November 15th of this year.
I guess I'll withdraw my motion. Deb, what would you recommend? Today is Wednesday.
It is. So I think one of the primary questions here is how would the board then place the school without another meeting to actually place the school before November 15th? concerning the actual data, again, for this school, because they were calculated as a combined model, they have both their elementary data as well as their high school data. I believe what I was hearing in the earlier commentary, although I've not seen it in a written appeal, is to actually use the elementary middle school data rather than using the combined elementary and high school data. If that is in fact the appeal, then we do have those points as well as the grade that would be assigned. So I guess we could move forward with clarifying if that
Deb,
is
is that
specifically the
information
appeal.
is that information that we can get today?
We can, absolutely, we
So
can go pull that up.
perhaps we should table this till later on in the meeting, and actually look at the data, so that we can take some type of action, although we would be taking action without a formal appeal, which I feel very uncomfortable with, but, we are dealing today with the placement of school grades. So perhaps we can just deal with it in the placement of school grades.
They're still here, do you want to ask if they're comfortable with that? But I mean, to give you comfort in saying, without filing an appeal, they're comfortable with us just reviewing the data and
Well,
giving us their blessing?
for the department standpoint, we need to have a record of a formal appeal. Shouldn't be,
Can I ask a question on that? It would seem like the board vote just counteracted the need for that, because the board just said, we're gonna let them appeal. There's an appeal. I could be wrong on that, but I mean, that was the motion, right? We
Deb-
just agreed to
Deb,
let
why
them
don't you
appeal.
give us your best thoughts?
I think we'd like to see in writing specifically what it is they're appealing. Are they requesting that they receive the elementary, middle school data only? Are they requesting that it be calculated some other way? At this point, I think we're just operating under the assumption that it is just a grade based on the elementary data alone. However, I think we would need to at least see that in writing, at least submit it through an email, to have a record of that's what was being appealed.
We also may have the option to do what we just did with these 4 schools, which is use the same model. Elementary, middle, so let's, I guess I'm gonna make a motion to table until later on today, so that we have some information, and perhaps you can work with the school to see what it is that they want calculated, and perhaps then we can proceed with the placement of grades here later. So, a motion to table till later on today's business.
Second.
Any more discussion? Roll call, please, for tabling.
Yes. Yes.
Yes.
Yes.
Yes.
Yes.
Yes.
Yes. So, let's recap what it is that we've already done under atypical. So we have placed the elementary, middle school model only for these 4 schools. And and you see the grades before you. And we have had a motion for haste and working through that issue. And so our next appeal that came after our October 15th meeting, that we already took action on at our October 15th meeting, is from Carpe Diem. And Carpe Diem is requesting that they use a growth only and have no grade. So, we took action already on Carpe Diem. Are we taking further action?
Madam Superintendent,
Yes.
there may be other people in the audience. I know of at least one person who's here to raise some other questions about the A through F model, and was wondering if it would be appropriate now to hear that public testimony.
It will in just a moment.
Okay, I
When
just
we
want
get
to
to
make
the
sure
next
we get
section.
to it before we get to the next topic.
Yeah, we're going to approve the final placement of grades here.
Right,
So we have
correct.
several people that are wanting to speak.
Okay, just want to be sure we do it.
I don't hear a motion to do any further action with Carpe Diem. So we'll move on. So I think that concludes action under atypical. All right, our next item of business is the approval of final placement of schools into categories of school accountability. And I have several speakers. The first one is Melissa Briscoe.
Ladies and gentlemen of the State Board of Education, my name is Melissa Briscoe. I'm the Chief Academic Officer for Wabash County Schools. I appreciate the opportunity to share with you an issue related to the MSD Wabash County School letter grade that significantly impacts both high schools as well as the district letter grade. The district's concern is with the appeal process. Upon receiving the preliminary letter grade, Northfield Junior Senior High School and Southwood Junior Senior High School noticed that several students who had earned dual credit were not listed on the report. The district filed an appeal for both schools. Southwood had 7 students and Northfield had over 30 students missing from the data. The district followed the directions on the DOE website in order to submit the appeal. We completed the documents provided by the DOE and submitted the appeal within the window. The DOE's appeal direction stated that all questions related to the appeal process should be directed to our outreach coordinator. In order to make sure we hadn't missed anything, we sent an email to our outreach coordinator that contained all the data submitted. We simply asked for him to review what we had submitted to ensure that the appeals committee had everything they needed to make a decision. The outreach coordinator responded that the appeal was complete. The communication with our outreach coordinator was done during the appeal window and with ample time to submit any additional data if necessary. Since we believed and our outreach coordinator confirmed that we had submitted the necessary information for the appeal committee to rule on our appeal, we were completely surprised when we received notification from the DOE that our appeal was partially denied because we lacked sufficient documentation for our dual credit students. The district attempted to contact the DOE to discuss the matter further. The response we received was the DOE policy is not to discuss the appeal decision until final grades are released. Discussing this process after final grades are released does no good for the 2 high schools or the district. The additional dual credit students would increase the district's letter grade and 1 high school letter grade. If the goal of A through F system is to fairly and accurately communicate the school and district's academic performance, then MSD Wabash County Schools should be allowed to submit the dual credit information the DOE needs to determine the district and school letter grades. The district followed the DOE processes and protocols. The DOE failed the district. We respectfully request the opportunity to provide the necessary dual credit information in order for the district to be graded fairly. Too much depends on letter grades to get it wrong. We live in an age that forces school districts to compete for every student and every dollar it can. Teacher evaluations and compensations are partially based on the school's letter grade. Not allowing the 2 high schools to provide the additional dual credit information severely penalizes the entire school corporation's students, teachers, and administration. Wabash County School respectfully requests the opportunity to submit the missing data to ensure that the most accurate and fair grade is applied to the high school and to the district. Thank you.
Thank you. David Chapman.
Could we ask the Chief Academic Officer, I cut the title, I'm sorry. I'm sorry, I didn't be just, may I ask a quick question about, do you have a email stream of your claims?
I do. I didn't bring it with me because I submitted it to the entire board, including Mrs. Ritz, through an email to you earlier as well. But I can forward it to you again, absolutely.
Dr. Oliver's going to re-forward it to me. He says, I wanted to see a written record of the claim.
Absolutely.
I understand then there is a written record.
In your packet.
There is a written record of the claim and absolutely correspondence with our outreach coordinator, his response back to us, our correspondence with the DOE asking to be heard before the final grade was released, their response saying that the policy is not to talk about final grade determinations until after they've been released to the public, and our response saying that really doesn't help us with that practice or procedure.
Thank you.
You're welcome.
I do have it here.
We've got it.
Deb, did you want to address the appeal? Danielle?
And I do believe, I think everybody has the information that she just mentioned. We'd also like to note that there are 3 opportunities for the student data which is in question, which is the dual credit work. There's 3 reports submitted to the department and also back to the school for them to clean up their data. There's a course completion report. There's a dual enrollment credit report, both which were sent back to the corporation in question. They did not clean up their data at that time. The 3rd opportunity is through the appeals window, and they did not submit any student-level data, which is required by the appeal.
Thank you very much. David Chapman?
Can I ask a question, just to follow up on that comment? I mean, what's your response?
That's what I want to know.
Because clearly there was a screw-up here, in my opinion.
Sure.
And I'm just, the school district was, in my view, just based on reading what has been submitted to us, was given essentially incorrect info. They were directed to go to the outreach coordinator, and the outreach coordinator said their appeal was okay.
I think you
All right,
also...
if I'm oversimplifying it, maybe.
I think you may be, and I think if you further read in, and this is from memory, but I also believe Melissa Briscoe even responds later and says, I understand that the outreach coordinator's opinion is not necessarily binding, but rather someone who can help answer questions about the process.
Right.
And our directions are clear, it's about the process. Our directions are further very clear that if you do not submit student-level evidence, what else are we able to grant an appeal on? They did not submit any student-level evidence.
Okay, I understand that. At the same time, I appreciate the position that the district is in, and that they were told to go through the outreach coordinator, and they understand that the outreach coordinator might not necessarily have all the information.
Correct.
So, but that's their liaison to the department, okay? And it just seems to me that if they cannot rely on the outreach coordinator, who's their liaison to the department, to get them the right information they need to rely on, if he gives them a thumbs up, they're relying on that. And they know that he's not necessarily the one who, is going to review the entire appeal. I'm just concerned about this because, they've been directed to...
Excuse us, then we can answer your question really clearly.
I'm sorry,
About
I
the
haven't
outreach
finished
coordinator.
yet.
Well, the outreach coordinator did give the right information.
I'm still speaking. I'd like to finish my thoughts. If they are not given the correct information, how can they, from the department, and I understand that there may be someone else in the department who may have the ultimate responsibility to check every box, but if they can't rely on the outreach coordinator, I'm just troubled by that.
Sure. In this particular situation, what we're looking at and what we're really expecting the outreach coordinators to communicate to the school is, again, what the procedure is and what the process is. For this appeal, what was being responded to was the appropriate documents that are required to submit an appeal attached. And the answer was yes, they did actually submit the required assurance document that was signed, as well as a file indicating which students were being appealed. Other information is optional to submit by school. In other words, specific evidence to provide support of the case that's being appealed is optional. The school may feel that evidence is already within the application center, therefore no additional documentation is necessary. In this case, no information for these particular students that were denied was already in the application center. Therefore, the expectation is that additional documentation would also be uploaded to prove that these students did in fact receive the required 3 college credits awarded by a regional accredited post-secondary institution. That information was not provided in this appeal. at the level of our outreach coordinator, when they're looking at this to ensure that that appeal was successfully submitted, what they're looking at is ensuring that the assurance form was signed and submitted along with the appeal, as well as ensuring that the list of STNs that are being appealed was provided in that appeal as well. That's really truly the end of their responsibility in looking at this. The deeper information of looking at student by student to determine whether an appeal by student is approved or denied is part of the appeals process, and that's where the denial came into play. The specific evidence for each of those STNs was not provided to overturn the information that had already been submitted by the school through dual credit and DT.
I'd like to ask a question of Ms. Briscoe if she could come back, but I want to make a quick comment while she's coming up. And I haven't been in central office since 2008, but from 2002 to 2008, I was in central office, and it was a regular occurrence to talk to DOE. And I guess I'm just a little taken back to Gordon's point. I've always known the DOE to be very responsive and to work with schools and districts in a manner that help bring resolution. It just seems almost like we've gone somehow on a different path that I don't recognize that was there years ago. So I guess I'm concerned about what you're all saying and just the manner of which it's being said and the passion it's being said, because I had always believed the department was always working to intervene with schools and districts and give them the benefit of the doubt. And if it was a simple, this data is missing, if we just plug this in, everybody's in agreement, you just fixed it. Ms. Briscoe, my question's for you. I guess the question I have for you is when they were explaining their response to Gordon, I saw you literally about jump out of your seat, and I'm just going to make an assumption you want to offer something additional to the board. I'd like to hear it.
Yeah, two things. I'm sorry, two things. One, my response to the outreach coordinator that I understood was basically from his comment that said, I can't tell you what the grade determinant will be, but I can tell you submitted the appropriate documentation, which led me to believe that we had submitted everything that we needed to submit to fairly and accurately be assessed. So really it's about the process and about we're supposed to contact our outreach coordinator about the process, the complete process. So we sent them the documentations. I don't need the outreach coordinator to tell me that I have the assurance document and I've completed the other documentation. My question to him was, is this all we need? Have we submitted everything we need to submit?
Have we complied?
Have we completed the process in a way that they can determine if our A through F appeal is okay? His response to me was simply, I can tell you that you have all the documents. I don't have that in front of me. You can read it verbatim. But he cannot tell me if they will approve the A through F grade. And my response to him was, thank you for your support. I understand that you cannot tell me whether our appeal will be approved. But we've given you all the documents.
I don't hear you asking the board so much for an appeal as much as just to act on the data that you submitted at the time you thought you were appealing. I don't want to put words in your mouth, but
I am asking
the frustration I'm hearing is that
yeah.
you submitted everything you believed, you thought you were compliant, but
Yes.
the appeal is being denied on the basis that you didn't submit
Additional
data that you believe you submitted.
documentation. And I also received an email last week from someone from the DOE that explained the process. And I said, can you tell me where the individual data part, because what I just heard today is that it's optional. Well, that wouldn't be optional for us. We'd want to submit that data so you can see exactly which students have dual credit. That's not optional. That's something we'd want to submit today. That's the information that we want to be able to provide in order for our appeal to be heard in the most accurate and fair way. It's really about, we thought we had submitted everything, our outreach coordinator gave us the thumbs up that we were good to go, and then the appeal was denied because we were missing some data. And so we have that data. We'd love to be able to supply it so that the appeal can be heard based on the full weight of all the data.
I have a question. I know you're new. Those two reports, the CC report and the dual credit report, were they submitted prior to your employment?
Yes.
And so because they were submitted incomplete, basically by your school system, by your predecessor, how is that, I guess that needs to be fixed first.
Absolutely.
In my opinion, because that's the problem. It isn't the data was incorrectly submitted, and there is time for that to be adjusted. And of course, being new, you probably didn't know that until this time. And so, I'm sorry, but that's where I stand. I do those reports, and I have to follow through with that as well as a principal. And it is my responsibility to make sure that those are correct. And I even have problems later on, and I do the contact with the accountability department. And sometimes, I want answers immediately because I get busy. And I applaud them for trying to get back to me as soon as they can.
Right, and there are two things. We have began conversations with our counselors in our high schools to ensure that we are submitting the very best data that we can possibly submit. The second thing is that we've changed our data system so that will help us in the future. It just doesn't help us for today with this appeal. So we're trying to respond to those issues as well to ensure that when we're submitting something that it's as clean as possible.
I would also suggest that if you do change systems of data systems.
We already have, yes.
I will tell you this, the histories don't always align, so really keep an eye on that.
Yes, thank you, sir.
May I make a,
And I would say that the department is always reviewing its appeal process to be sure that we are having it the best that it can possibly be, that's going to be fair to all schools. So there are strict timelines and guidelines we have to follow so that everybody has the very same type of appeal. So I hear your concerns, and I will take them back to the department, and we will look at our appeal process.
I
can promise you
appreciate your
that.
comment, but I would say we followed the timeline, and we even received feedback from our outreach coordinator within the window. So if we needed to provide additional data, we could do that. And so that's the process part for us that we're hung up on, is that we followed the protocol, and the protocol failed us, we believe.
may I ask a couple questions?
Sure.
We have a school here that grade will improve with data that does exist. I will agree that you're new, but I thought outreach coordinators were supposed to help our people who are new get the data in. And so we have, in other words, you have a lot of teachers and people that have worked very hard there and students.
Right.
The data did exist. All you needed was a little help. And so I feel like, the facts are interesting here. We have a school that's done the work and earned the grade, but you're not going to get it.
Right.
This bothers me. This bothers me. It's an equity, and you even have all the documents here, and the outreach coordinator didn't give you the right information, so we're going to penalize you. That's what concerns me.
Sarah?
I think that the department has very clearly defined what the outreach coordinator, or the outreach coordinator's roles are supposed to be in this process, and I think that's very clear across the board. I think the problem at this point is that with this particular situation, that did not happen. Whether it was an overstep or a miscommunication, there was different information that was given that led to a faulty appeal, basically. My concern with this is that, aside from your specific situation, whether or not we should be looking at this again and allowing them to use information that they had thought was complete data set, my concern is that the outreach coordinators have been placed throughout the state to be the go-to contact for all of these schools. And I'm concerned that at this point, we are creating an environment where schools aren't necessarily going to trust that interaction and feel like they have the resource as is intended by the department. So I think that it's kind of a bigger issue in terms of the trust and communication there as well. And I think that whatever we do, I know there's no action here right now, but I think the outcome of this has bearing on that environment throughout the state.
And as I said, we are going to be looking at the appeals process in totality. Okay?
I guess I want to piggyback on Dan's comments. What I want in the end is for you to get the grade that your teachers and students earned. I'm not here to point fault. I don't know. You're new. I don't care who's at fault. What I want to happen in the end is for you and your teachers and your students get the grades you deserve. And I think the only way to do that is accept this information. I don't know what kind of can of worms it opens. But in my opinion, you have people that worked really, really hard for a year that's not going to be rewarded, and that's not fair in my opinion. So I hope there's a remedy to this, and I don't know what it is. Again, I don't care who's at fault. I don't know if it's you or, I don't care. But I know who did work hard and who earned a grade, and I would like to see them get it.
Thank you.
David Chapman?
Superintendent Ritz, members of the board, thank you for allowing me to stand before you this afternoon. I think it's this afternoon now. When I got here, it was this morning.
2 minutes.
2 minutes, okay. My name is Dave Chapman. I'm superintendent of South Remain Community Schools in Clinton, Indiana. I'm here this morning to address the appeal of our high school, South Remain High School, of which there may or may not be any recourse for us, but maybe there might be some help for schools later down the road. We appealed the high school's rating due to an error in data. On September 22nd, I submitted our appeal as a result of errors in data. There were 3 documents scanned by my secretary and forwarded through my email to the Department of Education. On September 23rd, I was informed that the appeal had been received. There was no further contact with the DOE until October 3rd, when I received notice that our appeal was denied due to the fact that the signed assurance statement was not included. I immediately attempted to contact the Director of Accountability, Superintendent of Public Education, and our DOE Outreach Coordinator. The only person to respond was Heather Baker, our Outreach Coordinator. I attempted multiple times via email and phone calls to reach anyone at the DOE who could provide some sense of response to my concern. I did not receive any type of response until last Wednesday. And all I could get in my response to my concerns was that the established procedure was followed. The reason for the omission of the assurance statement was a technical error, glitch if you will. When the documents were scanned in our copier, the assurance page, for some reason, did not scan appropriately. Instead, a copy of the student's transcripts were scanned twice. This wasn't picked up due to the fact that the title of the document was labeled correctly. In essence, it was a mistake. We weren't made aware of that mistake until October 3rd. The error in data that we appealed basically meant the difference between our high school receiving an A or a B grade. It may not seem like much, but for a small school district, one student makes a lot of a difference. It makes a big difference for those who work so hard based on all the accountability, high stakes that were faced to get that level that they achieve. Teachers, students, parents, our community all felt that this was an injustice. All I'm asking is that the DOE allow for mistakes in the submission. We're not asking to provide further documentation. The documentation was one student on our graduation rate. The student's transcript was submitted accurately. The spreadsheet for the A to F appeal was submitted accurately. What didn't transfer accurately was this page with my signature on it. And for that reason, our appeal was denied. I personally emailed the Director of Accountability and resubmitted this sheet, still within the window. Never got a response. I emailed Superintendent Ritz. I did not get a response. I'm not here to make waves. I'm just here to do what's right for our schools. As it stands now, if anybody in my office, myself included, hits the wrong button on our computer when we send something, we're not allowed to make that correction. I don't know why. Mistakes do happen. Nobody in this auditorium that I'm aware of is perfect. myself included. I want to take you back to the spring when the DOE announced the 2012-13 four-star schools. That recognition was made in April. We weren't on the list, none of our schools, and we went forward. We strive for that. However, in late July, early August, we were notified by Dr. Frampton at the DOE that due to an error in the math calculations, we were misrepresented. And because of that glitch, if you will, our high school was added to the list. We did receive four-star status. I guess my question is, what kind of message are we sending? The school corporations can't make mistakes, but the DOE can. And they can make up for those errors. All I'm asking is that the State Board of Education look into this matter to fix the issue at hand. Mistakes, honest mistakes, do happen. Errors do occur. There needs to be an avenue to correct them. Everything we did was well within the time frame of the submission window. We did not delay, we did not do it. I ask for simply that our request for your review of our appeal be reconsidered. Thank you.
Can I ask one question? Thank you, Superintendent. You said you submitted the form that you failed to submit originally. You submitted that within the appeal window?
Yes.
So what was the basis for the denial then?
That this form, the assurance page signed by me, submitted through my secure email address, was not received.
But you said it was sent before.
I resubmitted it afterwards. The problem was the technical error glitch, if you will, was the copier machine. It scanned a student's transcripts twice rather than once, and this sheet with it. The DOE did not receive the assurance page signed by me originally.
When did you find out they didn't receive it?
October 3rd.
But you're saying, I was under the impression that they had received everything before the end of the appeal deadline.
They received initially my submission on September 22nd.
Okay, so, and then you didn't...
And I did not hear from the Department of Ed until I was informed it was denied. The appeal was denied on October 3rd. I think
it was denied on the basis
email was October 2nd. I saw it in the morning when I got into my office on October 3rd.
And so, anyone from the DOE can feel free to comment. Is the only reason that the appeal was denied that they didn't receive this form?
Correct, and if Deb could address that. This is an assurance form that is required. We require many assurance forms from school corporations because we have to have those on file that the data submitted is correct data from their corporation. So that is a required document that be submitted. So go ahead, Deb.
If I may, my issue is where is there an avenue if a mistake or an omission was made? Why doesn't the DOE say, we've got all your data here, but we didn't get this sheet?
Responsiveness.
Mr. Elsner, you mentioned earlier in your previous comments about fairness and what is earned. That's all I'm asking for. We submitted all the data.
Deb, could you speak to the appeal process that's been in place for
I got the same response from them as I did
quite some time regarding assurance forms? This is prior to me. This is an assurance form that has to be submitted. Go ahead.
Sure. For each appeal window, we do establish a process as well as criteria for the appeal. An signed assurance form is one part of the appeal. Consistently, appeals are denied if that assurance form is not provided. As stated, the submission during the appeals window up till September 28th for this school in particular did not have a signed assurance form. Appeals are then reviewed based on the information that was provided in that appeal. Therefore, the appeal was denied. After the denial letter was sent to the school, we did then, in fact, receive the signed assurance form. But again, consistency in the application of this process has been these appeals are denied if all criteria are not provided during the appeals window.
You may, Carrie.
So Deb, you said that consistently appeals are denied when the form is not included, and I don't doubt you need the form. I don't question you need the form, but does no one call and say you're missing the form? I mean, does no one say you're missing this one last page and their window is still open and hurry and get it to us? And when you say consistently these appeals are denied due to this form, how many schools are we talking about consistently? 2, 10, 12?
I don't have the count of the specific number that have been denied, but I believe it's approximately 5 this year that were denied.
So 5 calls?
That's, no one calls those 5 people?
So again, the process is to evaluate the appeals based on the information that was provided during the appeals window. And that has been a consistent application of that process through many years.
I don't know what was meant by the superintendent's comment about prior to me. I mean, if the form predates the current administration, I don't understand why, I mean, when the department's asking the board for direction, I would hope everybody on the board would agree that during the appeal period, the department is being as responsive as it can be, so that when the grades are recommended to the board to finalize, we feel pretty comfortable that those grades reflect what's really going on in the school. This is, I'm stunned that we're hearing what we're hearing, because I'm almost hearing like, well, you know, it's just cut and dry. And I've never known the department to be that way in an appeal period. I mean, the historical, now, I mean, we've got other administrators sitting in the room. Historically, I don't think I'm out of line saying this, historically, the department has always been responsive to the districts and the schools, recognizing that sometimes LEAs make mistakes and sometimes it's the SEA that makes a mistake, but the purpose of the appeal period is to reconcile the errors, to get it as right as we can in the end, so when the board takes action, everybody's pretty comfortable, we're all on the same page. So I guess I'm struggling with this, I really am.
Brad, I have noted that. I've noted that we need to be reviewing our appeal process, and I've heard you pretty clear about within the appeal process, within the window.
And I'm not going to belabor this, but I would say on the agenda, and it's within the board's purview, and I think frankly we've been lax on it. We have a strategic plan now, and we need to make sure that in our strategic plan, our resources and personnel are aligned with the plan. And I want to look at personnel, how they're trained, what kind of customer service we give. If I have teachers work, and some of them work unbelievable hours, and principals what they put in, and over a simple form, we won't pick up a phone and call them, I am embarrassed.
I'd just like to add, you know, I don't think anyone is absolving the districts of responsibility for submitting all the documentation here. But at the same time, I don't think that, you know, the Department of Education is a federal court where every I's got to be dotted and T crossed. I mean, it seems like there should be some kind of collaborative discussion, collaborative environment, such that the schools, so that there's not this type of great inequity just because someone left out a form. You know, again, I think it's an extremely unfortunate situation that we're in right now, and we're hearing from school districts that have worked extremely hard and potentially are at risk for receiving lower grades because of a technicality. And, you know, I appreciate the department's responsibilities, but at the same time, I just feel like what I've heard is a very bureaucratic response. You know, the form wasn't in there, so tough luck. Tough luck. And I feel that, you know, the State Board of Education here, you know, there may be a technicality where you deny an appeal, but I feel, you know, I'm here to resolve inequities, you know, and I feel like there's been a great inequity here. You know, I think it's unfair. So I don't know what we do to resolve that, but I just feel, you know, it's troubling to me to hear a response that just seems very bureaucratic. That, you know, and I understand you got to have rules and a process, but at the same time, we're not talking about a lot of appeals here. We're talking about a very limited number of appeals, so it just seems to me like this is in a very unfortunate situation for all parties.
Thank you. Chris Gibson?
Superintendent Ritz, members of the board, good afternoon. My name is Chris Gibson. I'm principal of New Tech Institute in the Evansville-Vandenberg School Corporation in Evansville. My comments this morning are in regard to our accountability grade. In mid-September, we learned New Tech's A to F accountability grade, which we appealed on the basis of incorrect use of the model. On September 29th, I received email communication from the IDOE that our appeal was denied, but the explanation letter had a critical typographical error. I called and emailed representatives of the IDOE on 4 consecutive days and received no response. Finally, I was able to speak with Amy Horton, who said she would get an answer for me soon. Later that day, I received an email stating that there was no error in the letter, along with a corrected letter, and instructions that no information about our appeal would be discussed until after final grades were approved. This response leaves us without any answers or explanations about our school grade. New Tech Institute started as a high school in 2010, and we added a grade each year. As of this year, we have 4 complete cohorts in New Tech, as well as 1 cohort of graduates. However, we are still assessed using the 9-10 model. Our concern about school grade centers around how well our students are performing. Our 2016 cohort had 88% pass rates in Algebra 1 and English 10 end-of-course assessments. That cohort of students finished this past year with 51 sophomores. 46 of them were included for accountability purposes, the 162 days. Of those 46 sophomores, 33 of them were in our corporation in the 8th grade to provide growth comparison purposes. So of these 33 sophomores, 89% of them passed the English 10 end-of-course assessment, and 7 of them, or 21% of them, demonstrated growth from 8th grade I-STEP and English Language Arts to the English 10 ECA. Ordinarily, that growth would merit bonus points. However, because we are graded on the 9-10 model, that was not reflected in our grade because we are on the 9-10 model. At the last state board meeting, the comment was made that a school's accountability grade shouldn't be based solely on its sophomore class, and I couldn't agree more. Our 2014 cohort, which graduated this past May, had a 95.3% graduation rate. 78.3% of those graduates classified as college and career ready by the IDOE. However, again, despite having a graduated class and 4 cohorts currently at our school, our grade does not reflect this data. There are high schools whose letter grade is higher than ours, and which is to their credit, and I applaud them, and it's a result of their hard work. However, on behalf of our students and our staff and our stakeholders, it's frustrating that when our ECA scores, our graduation rate, and our college and career readiness percentages are higher than those schools, our A to F accountability grade is lower. That comment is to take nothing away from the accomplishments of the other schools, but it illustrates that we believe the state board should take all of our data into account before issuing a grade that is vital to our existence, especially because we are a school of choice. So in light of no solid answers from the IDOE in regard to this issue, I respectfully ask the board to reconsider New Tech's school grade. And I also respectfully ask the board to consider, as you explore changes to the grading formula in years to come, to consider these points that I have brought forward. And remain open to any questions. Thank you.
Thank you. Debbie, would you please address this particular instance? Thank you, sir.
For New Tech Institute in particular, the 9-10 provision within the rule was used to apply their grade. For this particular school, as noted, they do have a 2014 graduating cohort. However, they did not have a 2013 graduating cohort. So essentially for New Tech, all available data was used to calculate this grade, which is 9-10 only. They are not similar to other schools we've discussed that have elementary grades. They were not assessed under a combined model. They truly are just 9-10 only.
Thank you, Deb. Yes.
How can is there a remedy to, and my concern goes back to the previous 2 speakers as well. You have a school who has higher ECAs, correct me if I speak out of turn, Chris, I apologize, higher graduation rates and higher college and career ready percentages that received a B when other high schools received an A. Is there any, and again, what I want is the teachers and students that worked really, really hard to be rewarded for that. Is there any remedy to this situation?
Sure, so I think we've touched on this a few times as far as being able to use current year data, particularly graduation, college, career readiness information in a current year calculation for A through F, or in other words, in this case, being able to use 2014 cohort data for 2014 A through F calculation. What we really get into is a matter of timing when that cohort information is available. Currently, the graduation cohort and graduation data is not final for 2014. It does remain open into mid-November to allow schools to clean up their cohort and submit their graduation records. In addition, we do have a graduation audit that we perform on that data. Therefore, final graduation data isn't available typically until December into January. If we were to provide information, A through F calculations based on that data, we would be pushing those calculations back significantly. This is all hinging on an October 1st deadline that's established statutorily for schools to have until October 1st for 12th grade students to graduate on time. So in other words, a student in the 2014 cohort had until October 1st to complete their requirements and graduate with the 2014 cohort. There has been some discussions on can that date be moved. I don't believe that there is, I don't believe the stakeholders are in the opinion that that date should be moved up and not allow that time for those students to be able to graduate on time. So it's really a timing issue of being able to provide grades in a timely manner and not pushing those grades into the very late months of the year or possibly into the new year for the previous school year.
And with the data point of the growth from 8th grade ELA to 10th grade ECA, what is that statute that's not eligible, or what makes that ineligible?
Sure. Within the 910 provision, it does just outline the use of the ECA data only. Therefore, that improvement information is not included. I think that's something that we could potentially look at as we transition to a new model, new A through F system, is how we can actually have growth components for 9th grade and 10th grade, which I believe would be possible under the recommended system.
So that is state statute that eliminates, there's no possible way we can go back and add a data point?
It's actually the rules, within the rules, the 910 provision.
I have a question for council.
Yes, go ahead.
John, I got a quick question for you. If the board was to move on letter grades today, issuing them, we've heard 3 schools, 4 if I throw Hammond in there. If we issue grades today, does either the rule or the statute provide any relief once that final grade is issued? Because it seems like last year, I remember or recall some kind of provision that Michelle McCown brought to our attention that there was enough foresight by the legislature to envision something being found after the board set final grades. Is there a way for these districts or these schools to get relief if the board needs to move on it? Because I'm worried about the November 15th deadline date. So I'm starting to think about, well, do we issue grades now and then let them, so what are our legal options?
Brett, well, I was just going to make that very point, and I wish I would have done it earlier because I actually wrote it down. I believe it's statute, and you can confirm me, 2031-8-4, which gives us that cleanup period after we actually place the grades, and we've done that before.
Yes, I think
Am I
that's
citing
correct.
the right thing?
I would also point you to 20-31-8-6, and to respond to your question, Dr. Oliver, the board was provided with a memo from General Counsel in December 2013 that outlined the appeals process, and there's really there's sort of a robust appeals process that should happen prior to the publication of the grades, and this is pursuant to federal law, which requires that schools be given some sort of meaningful opportunity to review their data and to challenge it and to suggest changes to it prior to the publication of that. And then the statute I just cited, 20-31-8-6, is sort of a post-placement appeals remedy that allows them to appeal errors in their data and other significant issues. So in general, that's the statutory framework. I think again, because we're talking about appellate remedies here, these are remedial, and as I said earlier about remedial statutes and rules, they should be given broad effect to try to give the greatest possible effect to the remedy that the statute contemplates. And so given those parameters, I think the board has a lot of flexibility. It's going to have to view these on a case-by-case basis and ask itself, whether what it's being told by the schools is a reasonable justification to go ahead and allow those appeals process, or whether these would reasonably constitute errors or other significant factors, and therefore fall under IC 20-31-8-6, which is sort of the post-placement statutory appeals remedy that the legislature provided.
So Brad, with that, do you have a motion?
I don't know that I want to bring a motion. I think at this point, I almost would like to take a recess. I need a break. I don't know if anybody else does. Collect my thoughts, and then I might come back and have a motion.
So I want to, and then that's okay, but I want to point out also that the data that you received in the spreadsheet is the data information that we have before us today. And it includes the changes that we noted in the documents that we sent to you.
I'll be happy to share the superintendent with my colleagues up here too, as we hopefully can take a recess. But I guess where I'm thinking just out loud is that maybe it would be better to take action on the grades that we know of today, including the ones we just dealt with atypical, and so that we meet that November 15th deadline and allow these schools that have talked to us today that have very clear, significant issues to invoke the statute and seek relief that way. But that's just where my mind's at.
Well, I think it would be best to just go ahead and take the motion, because it's also lunchtime, and I don't want to delay this a long time, and it's already 12:30, looking at my watch. So if you have a motion to adopt schools, and you have some that you want to do in the cleanup, I mean, I think that's appropriate.
I really honestly have been sitting. I'd really like to recess. I want to think about it. That's just me. Somebody else may want to bring a motion, but
I'd like to get more, if we could take a break, then we could get clear on the statutes.
I just want to be sure that the board's not going to engage in discussion regarding the topic before we take a vote.
We won't.
All right, we'll recess for 10 minutes.